exactly 3 o'clock, 1 minute. And I'm Dr. Mangesh. On behalf of RPG Life Sciences, I welcome you all for today's talk on the telemedicine and medical legal aspects. I would like to take this privilege to introduce Dr. Paritosh Baghel, sir. Before that, I would like to share a few thoughts of mine. Like, dear friend, telemedicine is going to be the future of medicine. So this is why Government of India and MCI has notified the guidelines related to telemedicine. However, we need to understand its medical legal aspects as well as its intricacies and its implementations in our day-to-day practice. We need an expert who can understand medicine as well as legal aspects. And such combination is very rare in our medical fraternity, my dear friend. But today, we could achieve that. So, my dear friends, it's difficult to get such a person who knows medicine as well as legal aspect. And this mystery is resolved today. So, we have with us our speaker, one of the leading physician intensivist, most busiest but yet very approachable, very humble, never hesitate to help anyone who approaches him, highly respected amongst his patient as well as medical fraternity for his compassionate approach, knowledge and expertise. Let me take this privilege to introduce you Dr. Paritosh Baghel. He has done MD Medicine and LLB. He is a medico-legal expert. After completion of his graduation from Grant Medical College and Sir J.J. Hospital, he pursued his post-graduation in medicine from KM Sir G.S. Medical College, Mumbai. After that, he was associated with J.J. Hospital as an associate professor of medicine and head of medicine unit. Currently, he is associated with Fortis, SL Raheja Hospital as a consultant physician. Did his LLB from the Mumbai University. And he is associated with law firm named Lexus Firmus as a partner and takes care of medical legal aspects. He has not only developed expertise in managing critical patients, my dear friend, but diabetology, intensive care units, internal medicine, and as well as medical legal aspects. So today, sir is going to take us through telemedicine and medical legal aspects. Forum is yours, sir. Please. Thank you for joining.
Thank you, Dr. Mangesh, for such kind words. First of all, before I begin, I hope everyone who's there on this webinar are safe and sound, and they are maintaining their health. We are going through difficult times, and as we know that the government of India has come up with the telemedicine guidelines recently. They were published on 25th March, and there was a gazette for it. So it's a very important topic. In fact, telemedicine is the new normal which is going to have in our practice. And as we all know, it was considered, if you were to ask about telemedicine a few years ago, maybe around a decade or two, it was considered to be very futuristic and experimental. But it is a reality, and it is coming to be a reality today. And thanks to the advancement in the telecommunication and the information technology transfer mechanisms, it has completely changed the way we communicate with each other. And this advancement in telecommunication has not only has also touched our profession, our field, where I'm sure every one of us would be practicing some sort of telemedicine by calling our RMOs, the RMOs giving us the reports, checking X-rays. In fact, even patients would be sharing these details to you. Now, up till now, there was no legislation, no singular legislation to control the way telemedicine has to be practiced, and so there had been few cases we are aware of that there have been certain cases in which the courts have given the verdict of negligence in the use of telemedicine. So it was always an area which was gray, and which everyone, although practice, were not aware what are the guidelines. Thankfully, to this pandemic, we have come across to these guidelines. So we should know what these guidelines are for a safe practice. So I'm going to talk on this subject of telemedicine and telehealth. I'm going to talk on a brief history of telemedicine, then the laws which are applicable to the practice of telemedicine, and the legal scenario which was there prior to the publication of these guidelines. Then we should look into the guidelines as what are the important uh, points which we needs to understand before we embark on doing telemedicine practice, and also what after the guidelines, what could be the legal issues, are there something which needs to be addressed later. So let us begin with what is telemedicine. Let us understand. Telemedicine basically means healing from a distance. It is the transfer of medical information and expertise by use of methods of communication for facilitating the diagnosis, treatment, and the management. It is a remote delivery, and WHO has defined telemedicine in 1997 as the delivery of healthcare where distance is a critical factor by all healthcare professionals using information and communication technologies for transfer of valid information for diagnosis, treatment, and prevention of disease and injuries, research and evaluation, and also for continuing education of healthcare providers, all in the interest of advancing the health and individuals and their communities. So telemedicine is a broadly defined subject where basically clinical services are provided to the patients who are away from us. There is another term called telehealth, which is defined as a delivery and facilitation of health and health-related services, including medical care, provider and patient education, health information, and self-care via telecommunication and digital communication technologies. It's a much broader term. In fact, if you look at it, telemedicine is one component of a telehealth. Telehealth is it encompasses everything, right from education, health education, to counseling, not just the treatment part. Both telemedicine and telehealth are used interchangeably, but this is the basic difference between telehealth and telemedicine. Now, when we look at telemedicine, first thing is whether what are the advantages, what are the disadvantages of telemedicine? Yes, it expands the access to quality patient care in the remote areas which cannot come to good places for medical care. Convenient access to patients. It's also convenient for both, for the doctors as well as the patients. It saves time for the patient. It is less expensive, yes. Maintains privacy if used in a proper way. No exposure to contagious diseases, especially as we are going through this pandemic. It can be a source of increased revenue as there would be more time to see patients, better quality and patient care back because you can keep a follow-up of the patients digitally. But at the same time, there are disadvantages of telemedicine that one has to be really technology savvy and undergo training, because the data which we are going to generate on telemedicine online is going to be can be misused or can be hacked by someone. So one has to be technology savvy, undergo training, investment on equipments are required. Also, it may become a very impersonal affair if there is no one-in-one in-person consultation. Also, as I told you, concerns about privacy, confidentiality, security of patient information and treatment is a concern in telemedicine. And also, since it is not a part of the medical curriculum, so we are not very much used to how to use it. Also, there are no clarity about the medical-legal issues arising out of telemedicine use. And at present, there are no health insurance policy which factors the use of telemedicine. So these are some of the advantages, but overall, I feel that the advantages are much more as compared to disadvantages. So when we look at a brief history of telemedicine, the earliest published records of telemedicine was in the first half of the 20th century when ECG was transmitted over telephone lines from a physiology lab to a clinic almost a mile away. And then it further on, there was a real-time video consultation in 1959 in the University of Nebraska, when there was an interactive telemedicine to transmit neurological examinations. Also, biggest role of telemedicine was in the disaster management. NASA first used telemedicine services during the Mexico City earthquake and during the Armenia earthquake. So telemedicine found its role in not just treatment of patients, but also in disaster management. When we look at telemedicine in India, well, the whole telemedicine service comes under the jurisdiction of Ministry of Health and Family Welfare and the Department of Information Technology. ISRO was the first to start the telemedicine project in 2001, linking Chennai's Apollo Hospital with an Apollo Rural Hospital, Aragonda Village in Chittoor district of Andhra Pradesh. That was a step which started the telemedicine. And over these years, the ISRO's telemedicine network has come a long way. It has expanded to connect 45 remote and rural villages and 15 super specialty hospitals. And the work is in most of the telemedicine is working in most of the rural district hospitals in our in where medical care is difficult to access. And also, if you would find that it is used especially when there is large accumulation of population at a given point of time. For example, government of Uttar Pradesh practices telemedicine during Mahakumbh Melas. And also, it's just not with the allopathic medicine, even traditional medicine in India, telemedicine use has been extended, such as the National Rural Ayush Telemedicine Network. So when we look at the modern telemedicine, obviously now today everybody has got a smart device in his hand and he's capable of transmitting high quality videos. And so it has not just becoming telemedicine, use of telemedicine is not just a tool for remote areas. In fact, it is becoming a mode of convenient treatment and to deliver prompt care. So it is more about convenience now. How can telemedicine be used for? It can be used for education, it can be used for healthcare delivery, for healthcare management, home-based treatments, screening the diseases, especially in disaster management, where large number of people are affected, and the role in family medicine, role in public health. So telemedicine has got a wide application. So what are the laws when we talk about telemedicine? What are the laws which are applicable to the practice of telemedicine as of now? It's a blend of information and communication technologies with medical science. So basically, two various the medical science and the communication technologies are blended together, and that is how we get telemedicine. And so the laws pertaining to both the fields govern the practice of telemedicine. So the laws related to medical practice, the Indian Medical Council Act, the Drugs and Cosmetic Acts, Drugs and Cosmetic Rules, the Indian Medical Council Regulations, the Clinical Establishment Act, the Consumer Protection Act. All these laws which are related to medical practice are applicable to the practice of telemedicine. Also, the laws which are related to information communication technology, like the IT Act, which is the base, which is especially important when we look at the data which we are going to generate and the security, privacy of and confidentiality of the patient data. So the IT Act governs, including the IT rules, the information technology intermediaries guidelines, unsolicited commercial communication regulations, telecom commercial communication customer preference regulatory TCP regulation. Basically, they govern how we use the data, how the data has to be transferred. Is there any breach in the transfer of data? So that all is governed by the laws of information technology. Now, what was the legal scenario prior to 2020? Now, when we look at what happened when somebody is practicing telemedicine before these guidelines were published, I mean, there is no legislation which singularly deals with practice of telemedicine. Basically, laws which relate to the information technology and the laws which relate to medical practice, they both are togetherly used, are to be seen together. There is no single legislation. So definitely, we let us see what the case laws. There have been various judgments in which, when the practice of telemedicine was done, there have been verdicts of negligence against the doctors. Let us see what important cases. So in the first case, which was in 2005, Krishna Sharma versus Raj Hospital, there was a patient who was having pain in stomach and vomiting, where he was unattended by the senior doctor because he was admitted in a hospital under the care of the senior doctor, and his treatment was given by junior doctors on instructions which were given by the doctor over phone without physically examining the patient. Now, this falls into the category where a healthcare worker is communicating with a healthcare worker about patients. Now, ultimately, the patient died. He had acute pancreatitis, and the patient went into the court and he argued that the senior doctor, had he been vigilant during hospitalization or had he been present, the life of patient could have been saved. Now, the court verdict was that there is gross negligence and laches and awarded a compensation of 10 lakhs. So, this was in 2005, and the principle which were applied were basically telephonic consultation and the principle of respondent superior. Again, there was another case in 2006, Pradeep versus Ramakrishna Nursing Home. In this case, Serenase injection was given in case of anxiety and administered to a psychiatric patient with cardiac disease, and the patient was treated on phone, and patient was having no such anxiety or agitation. This is what was argued, and the court had held the action of doctor as negligent, and a compensation was awarded. Again, here the principle of law which was considered was the telephonic advice without obtaining a complete history. Also, there have been cases in foreign. Now, this case law number 3, Riggs versus Christier. In fact, this is a case from foreign. It's a foreign case where a child was operated by a doctor. After the operation of appendicitis, he was left from the hospital, and later on, the mother called the surgeon describing his symptoms, and so the doctor told her to come and pick up some medicines, which she did. Next day again, the boy had some issues, and the father had called this time, and he described more symptoms and was told to come and get some more medications. Now, it was later on argued that the doctor had not attended the patient and gave advice on the telephone, but the court in this case held that the defendant had not acted improperly in failing to see the patient personally, since he had enough information on which to make an accurate estimation of the child's condition. So there was no negligence. So the message which is there from this case is that obviously one has to do, whenever a teleconsultation is done, the doctor should be in a position to defend himself that the adequate information was available to him to make a clinical judgment. Now, the question which was also has come is, can a harm occur to a patient following a casual advice? Will that be constituted negligence? Now, as per the definitions, casual means which is uncertain and unpremeditated. So unless and until it is in writing, any casual advice, it won't be by a doctor, will not establish the doctor-patient relationship. For any negligence, the basic premise is there should be a doctor-patient relationship, and there should be the doctor should owe duty to the patient, and that the duty is breached, and that has led to a direct injury to the patient. So in this scenario, when an advice is given casually, it does not establish a doctor-patient relationship, and it does not entail liability. This is as per the reference from the law of negligence, Kameshwar Rao. Again, the question which was put forth in front of the courts is relying on reports of investigations. For example, there have been patients who give us reports on WhatsApp, or they, give a photo of the reports which are like an X-ray or a sonography, and we report on that there's nothing, it is all fine. So again, there was a case on this. This question was answered by the courts in Rahul Sinha versus Dr. Alok Mitra in 1995. A CT scan was reported, and that stated that everything was normal and there was no trace of cancer, which subsequently turned out to be a recurrence of cancer. The case went to National Commission, and it observed that it is prudent on part of the attending physician to have a careful look at the medical history of the patient before proceeding treatment on the basis of any scan report. So this applies to telemedicine, because many a times we do see the reports, and we without examination, without understanding the previous history, a clinical judgment is given. So relying totally on the impression of the radiologist, or for that matter on any report, is not correct, particularly when they have medical history. So the medical history has to be known, and clinical judgment about the further course of action should be only after the complete assessment of the patient has been done, either telephonically or in person. A similar case, an Australian case, where a GP was visited by a patient, and she had lump in her breast, and he advised mammogram and an ultrasound scan, which gave normal reports, but he did not confirm that the lumps were cystic. And so the patient again on several occasions has visited her, but he failed to re-examine her and relied on the report completely. Ultimately, since the symptoms were not getting better, she was referred to a specialist, where it was established that she had cancer, and which has already spread to her spine. So this case went into the courts, and the Supreme Court of New South Wales held that the GP was negligent for placing too much reliance on inconclusive results and failing to re-examine the claimant. So the court also held, although the defendant had not acted irresponsibly with his advice, but he should have taken into the consideration the risk, the magnitude of the risk which the appellant or the patient was exposed, if in case the diagnosis was incorrect, if he has relied only on the reports. So, and the most publicized case about telemedicine, which everyone is aware of, is this recently Deepa Sanjeev Pavaskar versus State of Maharashtra. In this, as we all know, the patient was suffering from fever and severe vomiting, and she was admitted in a nursing home where the doctors were not available. They were out on vacation, and the patient was treated by the doctors on phone, by hospital staff, without examination, as the doctors were out of town. One of the doctors started, then later on one of the doctors who was on vacation started the treatment of the patient telephonically by instructing on the on-duty nurse. The Bombay High Court had held in this case that the patient died because she was prescribed treatment over telephone without an appropriate diagnosis. So, however, when we look at this case, we find that the High Court was only concerned with the fact that there was a failure on the part of doctor to diagnose the patient, and it does not interfere with the. So, it does not basically interfere with the telemedicine guidelines. But yes, there was a huge uproar that telemedicine cannot be practiced after this judgment. But in fact, the treatment of the patient was done through telephone was only incidental to the conclusion of the judgment. So, when we look at all these cases, we find that it was very unclear and it was very unsafe whether to practice telemedicine and how are we supposed to practice, what are the standard guidelines and all that. So thankfully, this pandemic of COVID-19 has given the much needed guidelines which we can follow to practice telemedicine. So Union Ministry had issued the guidelines for telemedicine on 25th March. As you can see, these are the guidelines and they have been adopted in the regulations, the Indian Medical Council Professional Etiquette, Ethics and Regulations 2002, and they are now part of the Appendix 5 of the regulations. And these guidelines are basically designed to serve as an aid and a tool to enable the registered medical practitioners to practice telemedicine. So this has helped so we should understand these guidelines. How are we supposed to telemedicine so that the chances of litigation are minimal. So I'll go through the guidelines, what they are, the key provisions of telemedicine guidelines, how are they placed, how are we supposed to do our telemedicine. So basically the definitions are there. Guideline number 1.1.1 defines telemedicine, which is the WHO definition. Also it defines telehealth. At the same time, it also defines the registered medical practitioner. Registered medical practitioner is a person who is enrolled in the state register or the national register under the Indian Medical Council Act 1956. What are the scope of the guidelines? Who is supposed? I mean, what are the things which are covered in the guidelines? So these guidelines are basically meant for the registered medical practitioners. It covers the norms and the standards of practice during consultation, especially the teleconsultation. It covers all channels of communication, IT platforms, audio, video, text, digital messages, everything. What it doesn't cover, what it does not guide us upon are the specification for the hardware and the software and the infrastructure involved in setting up a telemedicine unit. It does not include the data management systems involved, the standards and interoperability of such systems. It does not include the guidelines, do not include the use of technology for surgical or invasive procedures. It also does not include about the research and continuing medical education activities. And it does not include treatment of patients outside India by telemedicine. So it has got no jurisdiction outside India. It's basically meant for treatment of telemedicine or practicing telemedicine in India or in patients who are residing in India. So who are entitled to practice telemedicine? Registered medical practitioners who are defined as per the Indian Medical Council Act, who are registered in the state register or the national register, are entitled to practice telemedicine from any part of India. So there is the geographical barrier of practice has been removed. I mean, it goes away with the use of telemedicine. And how can we practice? So there has been a provision that all of them have to undergo online course on practice of telemedicine within 3 years of notification of these guidelines. As of now, it is not clear who's going to conduct online. Probably we'll come to know in a few days how this online course is going to be and how are we supposed to get this online course done. So in the interim period, meanwhile, while this course is been updated and is being provided to all, the principles which are mentioned in these guidelines should be followed, and that will help us to practice. Also, there is a provision that henceforth, thereafter, qualifying such a course will be essential prior to the registration of a medical practitioner. So moving ahead, as we see, these guidelines are mandating this course to be done prior to the registration of all the medical practitioners who are going to be coming in practice. So RMP may use any telemedicine tool. Any tool can be used, for example, telephone, videos, devices connected over LAN, internet, mobile, landline phones, chat platforms. Any telemedicine tool which can help transfer of data can be used for telemedicine. Irrespective of the tool of communication, the core principles of telemedicine practice remain the same. So whatever tool you use, the principles of the use of telemedicine will remain the same. And the doctor is supposed to uphold the same professional ethical norms and standards as is applicable to traditional in-person care, knowing the intrinsic limitations of medicines. Also, we have to be very particular about the privacy, data, and confidentiality. The guidelines classify the telemedicine applications into 4 basic types according to the mode of communication, like video, audio, or the text-based. Now, video is real time. Audio can also be real time. Now, text-based can be real time when you're chatting on an app like WhatsApp, or it can be asynchronous, or it may be delayed response like email, fax, asynchronous types. According to the time of information transmitted, as I told you, real-time video, audio, text interaction where you are able to interact with the patient in real time, or an asynchronous exchange of relevant information. For example, a patient gives you lab reports or images in your mail and you see it later on. According to the purpose of the consultation, it can be a non-emergency consult. For example, a patient coming to you for regular visit. It can be first visit, or it can be a follow-up consult, or it can be an emergency consultation. And this emergency consultation will be mostly by those patients who are your regular patients, and they will be calling for immediate assistance. In fact, in this, it is mandated that the doctor should be advise the person for an in-person interaction as early as possible, and give him the guide for first aid and facilitate the referral to a nearby center. According to the individuals involved in the teleconsultation, it can be either from a patient to the RMP, where the patients will connect to the registered medical practitioner, or from a caregiver to an RMP. For example, a person who's maybe bedbound and who's not able to communicate, he has got a caregiver and he wants to do a telemedicine consultation. He cannot come to your clinic, so caregiver to the RMP. And it can be a telemedicine consultation between a doctor, between 2 different doctors. For example, I want to know about certain reports or pathological reports or MRI. So RMP to RMP, or it can be a healthcare to RMP, which, for example, which we are currently also doing for our RMOs or our nurses who call us and update us about the patient's reports. So all these is also covered in the guidelines. Now, it is very important to understand that whenever we are practicing telemedicine, the professional judgment of the doctor should be the guiding principle of telemedicine consultation. I mean to say that whatever judgment we are going to give on telemedicine, what mode of communication has to be adopted, it is all the doctor is supposed to know and to decide which is best, and it should be used with proper discretion, and it should not compromise on the quality of care. The interest of the patient should take the priority, and on that basis, the decision about the use of telemedicine should be done. They should consider the more technologies available and their adequacy for a diagnosis before choosing to proceed with any health, education, counseling, or medication. So the doctor is supposed to know which mode of telecommunication is going to be the best in the interest of our patients. If you feel that this is not possible to do telemedicine, a doctor is well within his right to deny telemedicine consultation, and is supposed to ask them to visit as an in-person consultation. So telemedicine should be appropriate and sufficient. The doctor should uphold the same standard of care as an in-person consultation, but within the intrinsic limits. And identification of the registered medical practitioner the patient is required. So no telemedicine consultation can be done anonymous. So for example, a person calls to you and he just anonymously tells you that I need this. You just cannot give or prescribe anything on telemedicine unless you know the identity of the patient, and confirmation of the patient's identity is must either by name, age, address, email ID, phone number, or a registered ID, or any other identification which you can ask for. Also, when the consultation with a minor, now as per the guidelines, the age of minor has been mentioned as less than 16 years. So consultation with a minor less than 16 years is only allowed only if it is with an adult who's accompanying the minor and whose identity should be ascertained by the doctor. The RMP shall also display the registration number on prescriptions, website, electronic communication, receipts, etc. given to his or her patient. In fact, this a requirement of the law or the regulation is in-person consultation also. So mode of teleconsultation, again, RMP is the first person to decide the best technology which can be used to diagnose and treat, and that should be after considering the best interest of the patient. A patient consent is very, very important, like how we in an in-person consultation, when a person comes to you in your clinic, it is an implied consent that the patient wants to be treated to you. And otherwise, for any major procedures, an explicit consent or informed consent is required. Similar thing applies to telemedicine consultation. It is necessary for all telemedicine consultation. If the patient initiates the call, the consent is considered to be implied. But when a healthcare worker or an RMP or a caregiver initiates the call, an explicit patient consent is must. And what do you mean by explicit consent? Is that a person should be giving the consent, and that should be recorded in some form. Patient can send an email, text, or audio video message. The patient can state his or her intent on phone to the RMP, yes, I will consent to avail consultation via telemedicine, or any such communication in simple words. And the doctor is supposed to record this in his patient's records. What kind of information should be obtained from the patient during telecommunication, telemedicine practice is very important, that one should collect all the necessary information from the patient to be able to exercise proper clinical judgment. Because the law is very clear on this, that in case if you prescribe or give some treatment without an adequate diagnosis, it will amount to professional misconduct. And at any time, if the doctor feels that the information received is inadequate, he can very well request for an additional information. He can pause the telemedicine consultation at that time and ask the patient to come back with additional information. If a physical examination is required for consultation to understand the condition of the patient, he should not proceed with teleconsultation until that examination can be arranged through an in-person consult. Whenever necessary, he shall recommend either a video consultation. For example, a person is on audio consultation or patient is on chat or text consultation, and if you feel that there is a necessity for you to look at the patient or to look for the verbal clues or to look for the visual clues, the doctor can definitely ask for video consultation, or he can ask for an examination by another registered medical practitioner or health worker, or he can very well also ask for in-person consultation. It is very necessary for the registered medical practitioner to maintain all patient records, including the case history, investigation report, images, etc., as appropriate. Until what time it has to be maintained, it's not very clear. But as far as the regulations go, we are supposed to keep our records for a duration of 3 years. All the Indo papers should be kept for 3 years. The guidelines also define about the types of consultations which can be done. The first consult is when the patient is consulting you for the first time, and or he has consulted you earlier, but more than 6 months have lapsed since the first consultation, or the person is consulting again within the span of 6 months, but for a different health condition. So that will amount to first consult. Why this is needed? To know the first consult and follow-up consult is in matters of fees. Also, because in case of an emergency, no person will call a random doctor in an emergency for the first time. It's probably the follow-up consult time. The patient who has consulted with you previously will ask in an emergency. So follow-up consult means any person who has consulted you within the last 6 months, in the last 6 months as an in-person consultation or as a telemedicine consultation, and this is for the continuation of the care of the same health condition. But if there is a new symptoms and they are not as a part of the same disease, it can be considered as a first consult. Or if the RMP does not recall the context of the previous statement and advice, he can definitely take this as a first consultation. So after all this, taking the information, doing the consultation, what would be the outcome of teleconsultation? Well, a doctor can provide either a health education that includes the do's and don'ts about health, about diet, about exercise. He can otherwise provide counseling on phone. And the third option is to prescribe medicines. Now, again, prescribing medicines has been clearly defined in these guidelines. It's a professional discretion of the RMP. The doctor may decide not to prescribe any medicine and just ask the patient to do the counseling or the health education. Also remember that the same professional accountability is there in telemedicine as in the traditional in-person consult. Your liabilities remain the same. Only after the RMP has gathered adequate information and he arrives at a diagnosis is he supposed to prescribe medicine, because prescribing medicine without an appropriate diagnosis or provisional diagnosis will amount to a professional misconduct. Also, the guidelines have mentioned about the medicines, and there are specific restrictions on usage of certain medications. There have been lists about the use of medicines like list O. These are the common over-the-counter medicines which are safe to be prescribed. They have these are the drugs which a doctor can prescribe during any mode of consultation. This list is generally the drugs which are less addictive, or they don't have any abuse potential. List A is those drugs which a doctor will prescribe only during the first consult, and that too when the consultation has been done on a video mode of consultation. And when such a person consults for follow-up medication, these can be used as a refill for chronic illnesses, provided the person has been has come to you as a follow-up, and you can use these drugs to refill on any mode of consultation. List B is the drugs which are to be used only on follow-up consultation. These are add-on to the chronic medications to optimize management. This can be done on any mode of consultation. Then there is a specific prohibited list of drugs which is supposed not to be prescribed on telemedicine. These are the Schedule X of the drugs, the schedulized drugs as per the Drug and Cosmetic Act and rules, and also the narcotic and psychotropic substances which are listed in the NDPSA Act 1985. So these drugs are not to be prescribed at any point of the time during telemedicine consultation. For such, the patient is supposed to visit you in an in-person consultation. How to issue a prescription in such patient? Now, if the doctor has prescribed medicines, the RMP shall issue a prescription as per the regulations and shall not contravene the provisions of the Drugs and Cosmetic Acts and rules. He shall provide the scan or a photo or a digital copy of a signed prescription or an e-prescription to the patient via email or any messaging platform. You have to remember that it has to follow the regulations of prescription as per the regulations 2002, where the prescription should contain the name of the doctor, the qualification, the registration number, the address, contact details, the diagnosis, and the name of the medication, which should be preferably in capital letters. So this is the sample format of the prescription, which you can see on the right side. Also, in case if the RMP is transmitting the prescription directly to a pharmacy, he should make sure that he takes an explicit consent from the patient that he's okay with the dispensing of the drugs from a pharmacy of the doctor's choice. What are the duties and responsibilities of a registered medical practitioner who is doing telemedicine? Well, most of the duties and responsibilities remain the same, like how they are in an in-person consult. In fact, one has to be more vigilant about the data protection and privacy. So principles of medical ethics remain the same. They have to be upheld and practiced. Data protection and privacy is very, very important, and the registered medical practitioner should be aware about the usage of platform and about the usage of, the way he's practicing telemedicine. There should be no breach of confidentiality from his side. And it is very clear that the doctors will not be held responsible for breach of confidentiality if there is a reasonable evidence to believe that the patient's privacy and confidentiality has been compromised by a technology breach or by a person other than the doctor himself. So a doctor should ensure that a reasonable degree of care is undertaken during hiring of such services and using such platforms. An example is when I say, for example, a doctor is planning to create a virtual group support for disseminating health education for patients suffering from a particular disease, he should be really, really wary about the data privacy, and he should be taking a consent from the patient before adding him to a group where he wants to disseminate any kind of an education. So consent for adding of patient into any of the groups is must. Also, the rules and regulations about the misconduct of a doctor are as like an in-person consultation. In addition to that, if there is any act which violates or which compromises the patient care or privacy and confidentiality, the doctor will be held responsible. Example: if a doctor insists on telemedicine when the patient is willing to travel to a facility or request an in-person consultation, it will be taken as a misconduct. Also, doctors misusing or any RMP misusing the patient images and data, especially private and sensitive nature, it will be considered as a misconduct. Or if a doctor is prescribing medicines from a specific restricted list, obviously that will be a misconduct. And the doctors are not permitted to solicit patients for telemedicine through any advertisement or inducement. The regulations on advertisement remain the same as per in-person consultation as well. What are the duties and responsibilities to maintain the digital trails and records? Well, it is very important. It is incumbent on the registered medical practitioner to maintain the following records and documents for a period as prescribed from time to time. Log or record of the telephonic interaction, the patient records, reports, documents, images, diagnostics, data, etc. utilized in the telemedicine consultation, and also the prescriptions which is shared with the patient. All these should be kept for a period which is not determined, but as far as what it goes, that the indoor patient papers are supposed to be kept stored for a period of 3 years. Fee for telemedicine, again, it has to be treated the same way as an in-person consultation from a fee perspective. So the person can charge the fees for telemedicine as per his regular fees as an in-person consultation. Also, he is supposed to give a receipt or invoice for the fee charged for providing telemedicine. What are the provisions for penalties? Well, most of the laws which are as per the Medical Council, the IMC Act, the Ethics, the Drug and Cosmetic Acts, Law of Contract, torts, IPC, CPA, all apply to us. And in case if there is any misconduct on the part of the doctor, appropriate provisions will come into play. Well, so essential principles of telemedicine is very important. The professional judgment should be the guiding principle. Do not compromise on the quality of care. The same principles apply irrespective of the mode of telemedicine consultation. The doctor should exercise his professional discretion regarding the mode of communication. Depending on the type of the medical condition, in case if he feels that a video consultation is required, he should explicitly ask for it. Or in case if he feels that telemedicine is not appropriate to diagnose this condition or this patient, he should ask for an in-person consultation. At any point of time, he can choose not to proceed with the consultation if he feels that it is in-person consultation is going to be useful. He should definitely choose not to proceed with the consultation. Also, the patient has got a right to choose to discontinue the teleconsultation. One has to remember the moment when you choose not to proceed with the teleconsultation, it is important to record your notes as why you have chosen to discontinue the teleconsultation and why have you chosen the other way. So that has to be recorded in the notes. So this is the flow of consultation of a patient to a registered medical practitioner. A person calls to you for the first consult. His patient identification and consent is must. A quick assessment after obtaining the history, and then the patient management, either health education, counseling, or prescription of medications. Now for follow-up consult, again the same, it is almost the same. The only thing is that since follow-up patients are the one who may call you for an emergency, so quick assessment for emergency condition. If you feel that there is an emergency, provide the first aid, advise, and ask for and facilitate the referral to a patient so that he can be seen by someone in person. In case of routine follow-up, again check for the previous records, obtain adequate information to make a clinical judgment, and then guide him as per the patient management, like either prescribe medicines or give him the advice regarding patient education or counseling. What happens when the consultation is through a caregiver? Now, caregiver is defined as any family member or any person who's been authorized by the patient to represent the patient in terms of care. So the person may call the doctor for teleconsultation. Now, two scenarios are possible: when the patient is present with the caregiver during the consultation, or the patient is not present and the caregiver is calling you, or the patient is and the caregiver is calling you. In this scenario, it is very, very important that the caregiver has a formal authorization and a verified document establishing his relationship, and it should be verified, and it has been verified by the patient, and the doctor should verify this, that the caregiver is authorized and a permission has been taken by the patient to do a teleconsultation. Consultation between a healthcare worker and a RMP. The healthcare worker could be a nurse, doctor, junior level doctor, ANM, or any other health worker designated by an appropriate authority. The healthcare worker, when he wants to do a teleconsultation, he should obtain the patient's informed consent for teleconsultation. And the patient identification should be done by the RMP. The doctor should confirm the patient identity to his satisfaction, and also the doctor should make his own identity known to the patient and confirm the patient's consent. In case if there is an emergency situation, it is the duty of the healthcare worker who's seeking telemedicine consultation to provide immediate relief and first aid details from the registered medical practitioner, and the doctor who's providing telemedicine consultation should guide them for and help their referral to an in-person consultation. What about the guidelines also mention about RMP to another RMP specialist? Now guidelines are support and encourage the use of a consultation between doctors, especially like when we see teleradiology, where radiographic images are sent from one place to understand the diagnosis. Telepathology, the transfer of pathological data. Teleophthalmology, where doctors, eye specialists for patients in remote areas. So consultation from an RMP to RMP is also encouraged and supported by the guidelines. What to do in an emergency situation? Consultations as per the judgment. The objective should be to provide an in-person care at the soonest, advise the person for a first aid, counsel him, and facilitate the referral. That is what one should do in case of an emergency situation. Now, what are the guidelines for technology platforms enabling telemedicine? The technology platforms like the mobile apps, websites, which provide telemedicine services to consumers shall be obligated to ensure that the consumers are consulting with registered medical practitioners, duly registered with the councils of the respective state council and comply with relevant provisions. Also, the platform should conduct their due diligence before listing any doctor on its online portal. The platform must provide the name, qualification, registration number, contact details of every RMP listed on the platform. And in case if some non-compliance is noted, the platform is required to report to the MCI, which may take an appropriate action. Also, it has been clear that platforms based on AI or machine learning are not allowed to counsel the patients or prescribe any medicines to the patient. They may help to understand the data by a doctor, but not allowed to counsel the patient or prescribe any medicines. Only a registered medical practitioner is allowed to prescribe. Technology platform must also ensure that there is a proper mechanism in place to address any queries or grievances that the patient may have. In case any specific technology platform is found in violation, the MCI or the Board of Governors can blacklist such platform, which may not be available for their use by the doctors later. So these are all the guidelines. So what we should know, and when we know all this, most of the ambiguities are covered. Are removed by these guidelines. They have covered most of the aspects of telemedicine. But still, certain medico-legal issues which come to our mind, certain questions which come to our mind when we're able to practice telemedicine. I have just put down a list of them to see what one should do. So the risk of litigation for medical negligence. As we all know, medical negligence is the sword which is there on our head, and but one should understand that in cases of medical negligence, one should understand that there are two basic requirements which must get fulfilled. First is the doctor-patient relationship must exist, and the doctor should owe duty to the patient. And the doctor must have breached his professional duty of care towards the patient, and which has directly led to an injury to the patient. These things should be fulfilled. Only then can a medical negligence be proved against the doctor. So, doctor-patient relationship in telemedicine. Now, there have been case laws about doctor-patient relationship. Very important being the Supreme Court has had clearly, succinctly described the doctor-patient relationship, especially as we know this case of PB Desai versus the state of Maharashtra. And why this doctor-patient relationship is important? Because it is the cornerstone of the legal implications associated with medical practice. So fact is, when a physician agrees to attend a patient, there is an unwritten contract between the patient and the doctor. And so the responsibility is entrusted on the doctor for the treatment of the patient. And what are these responsibilities? It is to continue to treat the patient, except in certain circumstances where he need to abandon the patient. To take reasonable care of his patients, to exhibit reasonable skill and care for his patient, and the reasonable skill can be an average degree of skill which his colleagues possess. Not to undertake any procedure which is beyond his scope or control, and the the principles of professional secrets. So whenever there is a doctor-patient relationship is formed, it becomes the basis of a legal relationship. It starts a legal relationship between the patient and the doctor, and that forms the basis of the duties, the regulations, and rights and duties of the patient, and that forms the basis of liability of a medical practitioner towards it. So in telemedicine, when we look at it, the doctor-patient relationship, it is not very clear whether a doctor-patient relationship exists online or through email. Uh, it's not very clear. So, but I would say that when communication has been established, then obviously there would be a chance that yes, doctor-patient relationship existed, especially in patients who have been following up for a regular period of time. Also, in times of emergency situation, when the doctor is forced to treat the patient, it may not be considered to be a doctor-patient relationship, and so again, liability or litigation for medical negligence it won't be proved. So why am I talking about this doctor-patient relationship? Is because when we talk about the contract, when a person contacts you or when a person initiates the telemedicine, one should keep the records of telemedicine consultation, because as per the IT Act, the Section 4 and 5 has given legal recognition to the electronic records and digital signatures. So, and they can be, these electronic records are admissible in the court as evidence. So, whenever there is a consultation on phone, one should keep records to prove this, that there has been communication and a contact has been established, which can be either implied or expressed, and hence the relationship has been established. What are the standards of care? Again, standards of care in an in-person consultation have been laid down by the Supreme Court under a famous case of Poonam Verma versus Ashwin Patel. Again, telemedicine being a new concept does not have the same standards of care as laid down. Again, one has to understand that the standard of reasonable degree of care and skill are not mentioned or determined for the doctors practicing, as there has been no case of medical negligence as of now brought against such a doctor. Also, when we define standards of care, it has to be according to the location of experts. For example, a person who's teleconsulting in a city like Mumbai, or a person who's teleconsulting in a small village, the standards of care are going to be different. Also, as per their specialty and the media being used for telemedicine, so nothing is very clear as of now regarding the standards of care. So, the patients who should expect the treatment standard as per the area or as per the state of the country of the practitioner. Liability of doctors. So what is a liability? For example, there could be a case where the patient has messaged you or has texted you or has tried to call you, and you have taken some time to respond. So the delay in response and the patient suffers an injury. So is it possible that a doctor-patient relationship would be deemed to exist and the doctor would be held liable? Or if the doctor is on vacation and the patient believes that he will receive a timely response and suffers an injury because the doctor fails to respond, it's not very clear whether the doctor has a responsibility to respond in regard of these patients or to notify that the patient cannot assist him. But I think prudence will be that in case if you're on a vacation or anything, it should be made clear to everyone, whoever is in your list of patients who are to be treated should be messaged there, or at least there should be a blanket, maybe a notification that I am not available for so and so period, so don't connect, please connect to someone else. Probably that will help in matters of law or maybe cases against you. In case of errors which take place due to breakdown in communication, for example, you are working for a telemedicine unit which is organized, which is in your organization. Again, the summary of the principles of organizational responsibility should apply. There is a rule of vicarious responsibility. Also, the question about liability of doctors is when there is chances of miscommunication is very high in telemedicine because of internet connectivity issues, or the patient not understanding the instructions properly, as patient may not be near you where you can explain about the diseases. Many a times the patient may be not understanding the language of prescription which we generally write in English. So it is possible that patient may not understand and there will be a miscommunication. The patient may take medicines which are not prescribed by you, or there is a change in the dosage and the patient suffers. So in such cases, again, the liability of doctors can be patient doctors can be taken to court regarding this. So again, that is not very clear with these guidelines. So that needs to be taken care of. Again, the issues related to security, privacy, confidentiality. Again, these acts are governed by the IT Act 2000, but it is very clear that the health practitioner must maintain confidentiality, not only in telemedicine but also during the practice as an in-person consultations. The potential for leakage of electronic records is very high if things are not taken care properly. So the onus for safeguarding this information is on the medical practitioner. At the same time, the guidelines also have made it clear that doctor will not be held responsible for breach of confidentiality if there is reasonable evidence to believe that the patient's privacy and confidentiality has been compromised by a technology breach or by a person other than the RMP. So it is more so very important. It's very, very important for the practicing doctor who's practicing telemedicine that he has had sufficient data to prove that he has taken good care about the safety or the confidence of patient to maintain the patient privacy. The password have been protected. All those things has to be very so that you can put it in the court of law that adequate measures were taken to prevent the patient's privacy to be lost. So remember, liability of doctors remains the same as an in-person consultation. So one should be extra cautious to use the kind of platform for telecommunication as the misuse and breach of privacy of patient data is very high. What about product liability and technical standards? Again, it is the liability of the manufacturer for any harm caused to the patient by a defective product. Again, this would be as per the IT Act. Also, reimbursements. Currently, there is no provision for reimbursement for medical insurance. Patient may call you that I have consulted you. Please give me a invoice. I don't know whether they will be reimbursed. Again, that has to be looked at regarding the insurance. And also, the question will arise whether telemedicine was required or not in the given situation. It may be argued well by the insurance companies that in-person consultation should have been done at this time. So, but as far as the guidelines go, the RMP, registered medical practitioner, if he feels that the consultation can be given or adequate diagnosis can be reached up by a particular mode of telecommunication, then he is well within his rights to do that. And also, again, medical indemnity insurance in case of lawsuits for telemedicine, again, that is not very clear. I hope that our indemnity covers it. Again, one point which I feel that telemedicine by College of Physicians and Surgeons, I mean, those who have been obtained their degrees from CPS, again, as we all know that not people who are recognized, the doctors who have been recognized by the MCI can practice anywhere in this country. Now, again, telemedicine, when we talk about telemedicine, it is about no geographical barriers. Now, this question about doctors who have been recognized by the CPS, they are supposed to practice in a particular geographical location only. Now, what about if they do a telemedicine consultation with a person who's staying in some state where their degree is not recognized? So again, that is a factor. What probably they may not be able to practice telemedicine in their area of specialty, but as an undergraduate, they may be able to use telemedicine all over the country. Also, in cases of an emergency, what happens if if a patient calls in an emergency to a person from an area where his degree is not recognized? What will happen? I think in an emergency, probably it will be, because it's an emergency. It will be. It won't attract any legal suit. So these are some of the points which I feel that are very important legal issues after these guidelines. Most of the things have been cleared out by the guidelines. So the take-home message from my side would be that telemedicine is knocking at our doorstep. It is a need of the hour and holds promise in future, but one should be prepared for it. These guidelines, remember, do not dilute the duty of care by the registered medical practitioners. Keep patient interest as the topmost priority. Do not compromise on the quality of care. Follow the IMC Regulations 2002 as outlined by the MCI. Be aware of the technological pitfalls which can land you in a litigation. Be aware of the provisions of IT Act. Use secure platforms. Keep records as per the laws. Remember, the liability of the doctors remains the same irrespective of the mode of consultation. In certain principles of telemedicine practice are not yet defined, but always assume that they are going to be similar to like what an in-person consultation will be. And the basic principles of medical practice remain the same till the time we follow them. The risk of litigation is minimal even in the practice of telemedicine. Thank you.
So, yeah, thank you very much, sir. As you have covered not only the existing frame of law in India, as well as you have explained the guideline and what to be required in the future to have this guideline to be better. That also recommendations are indirectly given by you. So you should write all these, and these your recommendations should be taken care of. We'll take few questions. There are questions already in the question answer box.
Yeah.
You
So
have to
yes,
select.
yeah, questions. So I think I can see some questions. So first question, what I can see here is, can one use telemedicine if at all patient is not known to the doctor, approaches for consultation, say if in a containment zone? Yes, the answer is yes. It will be counted as a first consult, and one should follow the methods, the guidelines, the way in which the telemedicine consultation guidelines are, to take the consent, to take adequate information, confirm the identity of the patient, and go ahead with according to the available information. Whether you are comfortable enough to reach to a diagnosis, then yes, you can use telemedicine. So one can use telemedicine if at all patient is not known to the doctor, because that will amount to as a first consultation. Can you prescribe stimulants if a patient is to be prescribed refill of methylphenidate medication if patient reluctant to change the drug? Well, as far as if this drug comes into the narcotics and psychotropic drugs, you are prohibited from prescribing telemedicine. As we all know, Schedule X drugs and the drugs which are prohibited as per the Narcotics Act cannot be prescribed on telemedicine. If there is any doubt, whenever there is a doubt about any particular medicine, I would rather ask that the doctor should not prescribe it on telemedicine to be on the safer side, and ask for an in-person consultation and then prescribe it. What if the patient does not pay? Doctor has legal right to act. Yes, if it's applicable. Non-payment of fees, you can approach the civil court regarding non-payment of fees. Next is it essential to record the conversation? Again, this question now, you have to keep the records. It's not very clear now. It is essential to record the conversation because in case if there is a litigation later on, that can be used by the patient against you, and that can also help you to defend yourself. So record of conversation is essential, but at the same time one has to remember that this data of patient should not be leaked, or it should not be properly, it should be securely kept. That is very, very important. If I'm in US for a vacation, can I do consult? No. Trans-border consultation as of now has not been approved. Again, it will require a legislation about trans-border consultation. Dr. Shiva. Any other questions?
Right, so there is one question in WhatsApp asking that does Arogya Setu, as there is guidelines given, and Arogya Setu is using artificial intelligence to segregate the patients, would it be
Yes.
coming under the jurisdiction of this guideline?
Yes. So basically, Arogya Setu now, Ayush telemedicine guidelines are there. So if you go, if you search, you'll find out that there are these guidelines which are published, like how it has been published for us, for the allopathic practitioners of modern medicine. Similar guidelines have been published by the Ayush Ministry for practice of telemedicine by Ayush doctors. Again, Arogya Setu, it is collecting the data and it is asking for testing. It is not prescribing, or it is not doing any prescription. Health education is being done by Arogya Setu. Probably that is very well within the limits.
I think, yeah. And one more question. Many times we do text the medicines without mentioning our registration number and all. Do we have to follow the format shown by you?
Yes, it is must. It is mandatory. Tomorrow you may be prescribing a medicine to someone, and you never know who is going to take this medicine. You have prescribed it on a phone. You never know who's going to take this medicine. So it is always, it can be contended tomorrow that you prescribe the medicine for someone else. So it is always better to have a proper mode of prescription in which you know the name of the patient, and you write the name of the patient, you write your registration number, and you write you have a signature on it. So it is very, very important that whatever medicines you are prescribing, don't prescribe until unless there is a name over it to whom you are prescribing. Otherwise, it can be used against you in a court of law. There is one more question I can see. Can patient's relative communicate doctor and take opinion on patient condition? Yes, this will amount to the consultation between a caregiver and the doctor. Again, the doctor is supposed to confirm the identity of the patient and the caregiver, and the caregiver should have an authorization regarding teleconsultation. Does the consent prohibit recording of a conversation by a doctor in patient? Does the consent prohibit recording of conversation by a doctor in patient? I didn't get this question. Anshu, can I?
I think she might be asking that if consent is given, then is it necessary to record the conversation?
Yes, it is necessary. Absolutely necessary to keep the conversation with you, keep the record, all log records. All may not you may not keep the complete recording of the conversation, but at least the log records have to be kept.
Yes, sir. According to you, which are three to four key areas which are yet to be explained by these guidelines, which should evolve over the period of
Uh,
time?
as regarding the standards of care, the liabilities of the doctors. I mean, the standard of care is something which is very important, which have not yet been defined. As I had told you in the presentation, that the standards of care would depend on the area where the doctor is practicing, the mode of consultation which is using for consultation. That is one thing which needs to be clarified more. Second, regarding the practice, I mean, one is which I felt was there would be doctors who don't have MCI recognized degree. That needs to be thought about. Third is about the till this online course. Who would be the regulatory authority? How are we going to get this? Probably we'll come to know in subsequent years or subsequent months how things are going to be. They will get more clear. At least this is the first step towards the guidelines. At least it is very clear that telemedicine is legal and one can do telemedicine. Up till now, there was a question mark on doing telemedicine itself.
In-person consultation negligence and the consultation negligence by the telemedicine, does it falls under the purview of IPC?
Now, negligence, medical negligence. Now, again, if it is gross, yes, it does fall into penal code. I mean, when it is a crime, when the act is criminal, that will fall under the Indian Penal Code, and the person who has suffered or the litigant can definitely approach the courts. They also can approach the MCI, State Medical Council, regarding the negligence. So yes, if the conduct or if the act is gross, the doctor can attract criminal proceedings, I will say.
That's great. I think you have addressed the questions as well as you have addressed all aspects of these guidelines, existing laws and regulations, and the possible future evolution of this telemedicine guidelines, its limitations, its pros and cons. So I would say that you have touched upon all aspects.
Thank you so much.
Right, and yeah, and someone sent me a WhatsApp that you were addressing people through DD channel, DD National. Just I saw that. So I think just before starting this session,
Okay.
someone sent me that. Is it the same? So I think you were there on DD News just
Oh,
before. So
thank you so much.
yeah. So thank you once again, sir, for helping us to understand this telemedicine. And I would like to thank all participants for joining us today. What is your concluding remarks, sir, for the attendees?
Yeah, so the most important thing which I would say, be it telemedicine or be it in-person consultation, remember the liability remains the same for all medical practitioners. In fact, in the practice of telemedicine, one has to be more particular about the patient data security and secrecy, because we are not so tech savvy people as doctors, and the chances of losing the data or the data being misused by someone is very high. So one has to be very, very particular about that. Do an online course, which probably will be coming in some time. So that online course should be done. One should be aware about how to protect his devices in which the patient data is going to be there. Choose secure platforms And in case, keep all the log records so that you can defend yourself later on that this data privacy and confidentiality is not a problem from your side. There has been a problem from someone else. So that is the thing which is very important.
Shivam has conveyed. Thank you. Very informative session.
Thank you, sir.
Looking forward for more. And Anshu has also last question. If you
Yes.
can take it.
No problem.
Can you offer telephonic consultation to the patient overseas?
No.
What happens if case comes to court? Yeah.
No. At present, as with the present guidelines, no, you're not supposed to do any teleconsultation outside the limits of our country.
So thank you once again. We are terminating the.
Thank you, sir.
So thanks once again. Thank you all of you.